Sir, I think your screen is stuck. We can see the slide, but it's stuck. Do you mind stop sharing the screen and trying it again? Now.
Okay.
Yes. Okay.
We can see it now, sir.
Does that advance is that going, are the slides moving?
Yes, yes, sir.
Okay, great, thank you.
I also acknowledge the presence of Jennifer Pitts, ma'am. She has also joined us.
So you're muted. Professor David, you're muted.
Our Vice Chancellor, Professor Dr. Dilip Ukey, sir, has also joined us. We'll be shortly starting the meeting by 6 o'clock sharp.
Hello, Professor David.
Good morning.
Am I audible?
Good morning,
Yes,
good
sir, you are
evening.
audible. Sir, shall we start?
Yes, yes.
So good evening, everyone. A warm welcome to all of you to the third Professor C.H. Alexandrowicz Memorial Lecture. I'm Aman Khare, Research Assistant at Maharashtra National Law University, Mumbai, and we are very pleased to have with us Professor David Armitage, Lloyd C. Blankfein Professor of History and former Chair of Department of History and the Committee on Degrees in Social Studies at Harvard University. Prophet David Armitage will deliver today's lecture on sovereignty and statehood in the work of C.H. Alexandrowicz. Participants can post their question in the chat box. And I would like to invite Professor Dr. Dilip Ukey, sir, Vice Chancellor, Maharashtra National University, Mumbai, for the welcome address. Over to you, sir.
Thank you, Mr. Raman. Professor David Armitage, all my colleagues, Mr. Adithya, Variath, Mr. Aman, and dear participants. I'm indeed very pleased to deliver the welcome address of the Professor C.H. Alexandrowicz Memorial Lecture, which is being organized by Maharashtra National Law University, Mumbai. As all of us know, that Professor Alexandrowicz, who has played a very pivotal role, a phenomenal role in the development of international law here in India. In 1951, the Vice Chancellor of the University of Madras, earlier Madras, now it's Chennai, decided to set up a new department of international and constitutional law, the first such research department in India, when Professor Alexandrowicz was chosen to head it, to lead it. There he explored the history of international law in Asia and founded the Indian Yearbook of International Affairs. Over the course of a decade, Professor Alexandrowicz had created a Madras School of Law, which trained leading scholars of the field in India, as well as major Indian jurists and advocates. He wrote widely on Indian law and constitutionalism and acted as honorary legal advisor to the government of India and to Prime Minister Pandit Jawaharlal Nehru then. He associated with two of the authors of the Indian Constitution, Dr. B.R. Ambedkar and Alladi Krishnaswamy Iyer, and with Radha Govind Pal, the dissenting Indian judge on the Tokyo War Crime Tribunal, all of whom were members of the Indian Committee of Comparative Law, which Professor Alexandrowicz had initiated in the year 1953. Professor Alexandrowicz contributed to the effort of promoting the idea of international rule of law by rejecting a Eurocentric history and theory of international law. There is a great need to bring his scholarship to the forefront as an alternative to Eurocentrism in the history of international law. We believe that this lecture is our effort in this direction. For our first lecture, we had Dr. Karl, an international lawyer who spoke on C.H. Alexandrowicz, India, and the excavation of international law. For the second lecture, we had Professor M. Soranaraja, Emeritus Professor, Faculty of Law, National University of Singapore, who spoke on the past and present of Eurocentrism, the role of C.H. Alexandrowicz in resistance and change in international law. Today, for the third lecture of the series, we have with us Professor David Armitage, who will be speaking on sovereignty and statehood in the work of Professor C.H. Alexandrowicz. Professor Alexandrowicz had pioneered research in the critical history of international law, and the study of the history of international law is incomplete without referring to the work of Professor Alexandrowicz. Professor Armitage, along with Jennifer Pitts, have edited the book The Law of Nations in Global History by Professor Alexandrowicz, which brings together the first complete collection of Alexandrowicz writing on topics from pre-colonial South Asia to the international order of the 1970s. It includes the first biographical and critical introduction to his life and thought. Professor Alexandrowicz has been talked more and cited less, but the contribution of Professor Armitage has helped in bringing the works of Professor in the mainstream. Without much ado, I thank Professor Armitage for accepting our invitation. And at the same time, I heartily welcome him to the Maharashtra National University, Mumbai. And I'm looking forward to listen and hear from his talk. Thank you so much.
I would request Professor David Armitage to deliver the lecture. Over to you, sir.
Thank you very much. And thank you especially for that very warm welcome. It's a very great pleasure and indeed a real honor to be asked to give a lecture in memory of the great Charles Henry Alexandrowitz, and a great pleasure to be here with friends and colleagues, not just in Mumbai, but from also from around the world. I am sorry not to meet you all in person, but the virtue of the medium in which we meet on Zoom is that we can join colleagues from across the United States and also colleagues and friends from Japan and Europe as well. So welcome everyone. Good morning, good afternoon, good evening to everyone who has joined us. As I say, it's an enormous honor and pleasure to deliver this lecture, especially because I spent more than a decade, along with my good friend and colleague, Jennifer Pitts, engaged in collecting Alexandrowicz's writings, some of them very obscure, but as we've just heard and as others have assured us, very well worth recovering and bringing back into conversations about global history and the history of international law more generally. And also, along with Jennifer, we had the enormous pleasure, great fun indeed, of recovering Alexandrowicz as a biographical figure as well, turning somebody who, to me, when I was even a graduate student, was simply a footnote into a three-dimensional figure, and a very remarkable figure at that. You've heard a little bit of his biography already, and I'll fill in a little more of that in the course of this talk, and also introduce those of you who may be less familiar with Alexandrowicz's work to some of the key features of his writings and his thought, and perhaps also show some of the ways in which his ideas remain quite relevant, indeed pressingly, urgently relevant at this particular moment. The rediscovery of Alexandrowicz's remarkable legacy is not only the result of the recent edition that Jennifer and I produced, and which was so kindly mentioned, though that work does seem to have created much more focused interest in Alexandrowicz's work, but is also a great source of interest and indeed pride to see how Alexandrowicz's memory has been recovered in India itself. And this lecture is very much evidence of that. We learned in the course of our research for the volume and the biographical introduction, just how much Alexandrowicz owed to India, indeed how much he loved India and his Indian students in particular. So it's especially moving to be able to give a lecture in his memory at a major Indian law school like the Maharashtra National Law University. So once again, enormous pleasure and privilege to be here today. A pleasure, a privilege, and an honor, but at this precise moment in world history, also, one might say, something of a bittersweet moment as well. I chose my topic for this lecture, Sovereignty and Statehood, in the work of Alexandrowicz, long before this week's catastrophic Russian attack on the sovereignty and statehood of Ukraine. This is not only a major, and of course a retrograde turning point in international affairs, whose consequences will be with us for a generation or more. It is also an event that I believe would have torn the heart of Alexandrowicz himself. Alexandrowicz was born in 1902 in the city of Lemberg, then in the province of the Austro-Hungarian Empire known as Galicia. This city is now known as Lviv, and it is now in Western Ukraine. As I hope to argue in the next 30 minutes or so, Alexandrowicz was particularly sensitive to the durability of sovereignty within empire, and also sensitive to the historic rights of states that had been dismembered, that had been conquered, or that had been otherwise forcibly incorporated into larger imperial polities. I therefore believe not only would he have had very personal attachment to his home city of Lviv and what is happening there as we speak, the horror that is happening there as we speak, but even if he were looking from a distance at this, he would have been reminded of many earlier examples of sovereignties being overrun and subsumed within imperial polities. But as I will argue, he strongly believed in the continuity of that sovereignty, even under conditions of conquest or absorption. He believed that sovereignty and statehood were not extinguished by their incorporation or by conquest into larger empires, but that those sovereignties were kept in a kind of suspended animation, as we might say, to be recovered later. That was true, he believed, for his native Poland, and it was also true, he argued, for British India under the British Empire. I'll show how his origins in what is now Ukraine, when combined with his legal interests, the interests he developed as a trained lawyer, made him into a leading analyst of post-independence India and of the post-colonial legal order of the late 20th century more generally. I believe that Alexandrowicz's thought on Indian law, especially Indian constitutional law, needs more study, and it would be quite possible to produce a volume almost as rich and large as the one that Jennifer and I produced on Alexandrowicz's ideas about the history of the law of nations. One could produce an equally large volume based on his writings on Indian constitutional law. Karl Landauer, who I believe gave one of the earlier lectures in this series, has done some work on Alexandrowicz's Indian legal interests, but there is a great deal more to be written and said about that, and I will not be able to speak about that today. I'll concentrate instead upon what we've called his critical history of the law of nations, or what comes to be called later, of course, international law. In our introduction to the Oxford collection of Alexandrowicz's writing, Jennifer Pitts and I have argued that the origins of the critical rapprochement between the history of international law on the one hand and criticism of the impact of empire as a tool for the critical consideration of the history of international law, that lies in Alexandrowicz's work, very precocious work beginning in the 1950s. And we also argue that Alexandrowicz pioneered the historical study of international law in its extra-European contexts, along with many of his contemporary Indian colleagues, and as other scholars are now showing, along with colleagues in other parts of the world in the context of decolonization in the 1950s, particularly in Africa as well. This vein of the critical history of international law is now a research program that is fundamental to the history of international law as a whole, and it is becoming even more important within global history more generally, as law and the global history of law is mainstreamed into global histories written by historians rather than self-identifying lawyers. Now, unlike many contemporary scholars who assume that international law was, for example, an exclusively European phenomenon, or those who find only Eurocentrism in various forms in the history of European thought on international and global affairs, Alexandrowicz again precociously recognized international law's complicity with European imperial expansion and sought in history resources for a more egalitarian and less Eurocentric international order in his own time. A hope, we might say, again, with current events in mind, a hope for a more egalitarian and less Eurocentric international order, which is still to be achieved. In the era of decolonization itself, that is in the late 1950s, 1960s and early 1970s, when Alexandrowicz was at the height of his powers, in that period, Alexandrowicz used history to unsettle what he called the orthodox view that, quotes, new states, as they were often termed at that time, that new states are faced with the fait accompli of the existing international legal order and must accept its principles as they find them. That is, using history, he worked against the idea that the new, or as he saw them, renewed states, those that were re-entering the international order, did not have to do so on terms set by those powers which, for instance, had participated in the San Francisco Conference and had been founding members of the United Nations, but rather these new states brought with them continuities of sovereignty and statehood and contributions to legal order, which had to be respected and incorporated on their own terms, not subsumed into some kind of quasi-imperial order of international law, ordered hierarchically like the colonial come imperial order, which preceded their return to independence and their return to sovereignty after empire. His critical historical approach to the law of nations arose from interests in sovereignty, statehood, and the continuity of legal identity that, as I will argue now, began in Poland in the interwar period. Alexandrowicz's beginnings in Austrian Galicia inspired questions for him that would animate his scholarship across a career spanning from the First World War to the zenith of decolonization, a career that took him from Krakow in Poland to Cambridge via London, Madras, and Sydney. It's notable, and it indeed has been noted, that he came from exactly the same milieu in Habsburg Galicia, the greatest legal theorists of the mid-20th century, most particularly Herschel Lauterpacht, later professor of international law at Cambridge, and Raphael Lemkin, who did not have a conventional legal career, but of course is most famous for his role in authoring the Genocide Convention and making the crime of genocide itself a staple within international law. Both of these towering figures were also brought up and educated in Lemberg, now Lviv, though both, of course, were Jewish, while Alexandrowicz himself was Catholic, and that very fact explains to a large extent their rather different intellectual and professional trajectories. Alexandrowicz's own first scholarly and legal specialism was Polish marital law and its history, a subject on which he received his doctorate from the Jagiellonian University in Poland in 1926, and on a subject again on which he wrote his early articles in Polish and in Latin. This was still the age in the interwar period when scholarly publication, at least in Central Europe, took place in Latin. This is one of his earliest publications here from a copy from the British Library in London. Now that concern with marital law was central also to his interests in canon law, that is the law of the Catholic Church. And it may have become personally relevant to Alexandrowicz himself, who seems to have been married twice in Poland before the Second World War. Now, the reason why the law of marriage became so important for Alexandrowicz was precisely because marriage law was a pressing problem in Polish history itself. Because of Poland's history of partition and semi-extinction in the 18th century, its partial reconstruction after the Congress of Vienna, to which I'll return later, and then its subsumption into the Austro-Hungarian Empire, Polish marriage law was divided regionally and between canon and civil law, between Central and Eastern Poland, where Central Poland observed canon law alone, Central and Eastern Poland observed canon law alone, but Western and Southern Poland followed civil law in relation to marriage. The resulting confusions and collisions about such matters as marital consent, dissolution and divorce, and remarriage, or prohibitions against it, generated acres of contentious case law and fertile ground for work on the conflict of laws and for the enduring effects of historical legal pluralism. And this is very much where Alexandrowicz himself drew his later interest in the conflict of laws and legal pluralism, was precisely from this, for him, local and indeed ancestral example of these collisions of marital law in Poland. Alexandrowicz himself saw this as a richly fertile problem of comparative law, as he put it, the matrix of many of his later leading concerns as an historian of the intertemporal and transnational law of nations can be found in precisely this Polish context. Now, Alexandrovitz himself was a Pole by descent, but an Austrian by citizenship until 1919. He was thus a member of a suppressed nationality, the Polish nationality, part of a nation, Poland, without a state, which claimed continuity and identity under the integument of a multi-ethnic empire. The history of empire and of multiple claims to jurisdiction inflected his concerns long after he moved from Galicia to Tamil Nadu in the early 1950s. The defining question of his career, indeed, at least in regard to other international lawyers, that is, the suppression and recovery of sovereignty within and after empire, arose first not in post-imperial India, though it grew to fruition there in his writings and teaching, but rather in Central Europe and then in his exiles in Paris and London during the Second World War and immediately afterwards. It opened Alexandrowicz's eyes to illuminating parallels, for example, between the Holy Roman Empire and the Mughal Empire, but it also left him with a consistent equation in his work between sovereignty and statehood, and a general aversion to conceiving of empire, even in India, in fact, within the categories of colonialism. Thus, both his most original contributions and his most striking limitations can be traced back to the same roots in his life and work, all the way back to his origins in his Polish origins. Central to his work across a quarter of a century were exactly these questions of continuity and discontinuity in international law that went back to those Polish roots. And here I've just given you a list of his major publications for reference, some of which may be familiar to you, but if they're not, you can see the extraordinary range, not only linguistic range, but also the range of topics that he covered over a nearly 50-year career of publication. By the zenith of decolonization in the 1960s, Alexandrowicz posed a crucial question. Were the so-called new states, in fact, new or old, that is, restored or revived members of international society? Could sovereignty have endured under colonialism to be recovered after it ended? And was it possible to go back behind what he believed to be a hierarchical and discriminatory positivist international legal order to return to the vital foundations of the law of nations beneath what he called Bentham's international law, which continued to bear the seeds of its own crisis? That was the question as he put it, making a stark distinction between the law of nations on the one hand and international law on the other, which also relates to what he saw as a break in world history around the turn of the 19th century, which I'll again return to in just a moment to flesh that out. To answer questions like these, Alexandrowicz relied on the fundamentally historicist principle of intertemporal law. Lex retro non agit. Law does not work backwards, as it were. The past deserves to be viewed in light of the law as it stood at the particular period under consideration, he wrote. The law which matters for its proper understanding cannot be ex post facto law. Historical research was therefore, for him, essential to establish a universal and non-discriminatory international law in his own time, reaching back to the law as it was in force, for example, in the 1770s, rather than as it was in the 1970s, projected back to 2 centuries earlier. Alexandrowicz's own turn to the history of the law of nations, away from his earlier interests, occurred in precisely the context of debates around the so-called new states. That term most often referred to the post-colonial polities that emerged in the course of decolonization in the late 1950s and early 1960s. And here's an image from the New York Times of new members being introduced into the United Nations in 1960. That term, new states, appeared prominently in discussions among social scientists and lawyers at the time, often capitalized, new states, capital N, capital S. In this respect, it's striking that Alexandrowicz's earliest direct engagement with the urgent contemporary questions raised by emergent statehood after or out of empire, as well as his first tentative use of history to justify the emergence of a new state as the bearer of continuous sovereignty, was not in fact in relation to an Asian or African entity, but rather with regard to the state of Israel. In a short article entitled Israel in Fieri, that is Israel in the Process of Becoming, published in 1951, that is just before he moved to India, Alexandrowicz confronted the dilemma posed by the fact that the newly established state of Israel, established that is in 1948, could apparently not claim sovereignty by either of the established routes for the acquisition of such sovereignty. That is, it could not claim it by original title by occupation or derivative title transferred by another state. Yet, by meticulously tracing the post-Ottoman legal history of the Mandate of Palestine, Alexandrowicz argued that although Israel's sovereignty was indeed sui generis, it should be understood as continuous, that is, as having passed from the Ottoman Empire to the principal Allied powers after the First World War, and thence to the new state of Israel as its final legatee. The family of nations, as he put it, represented now, this is again in 1951 by the United Nations, then recognized Israel's membership and thereby affirmed its sovereignty. This is his argument. Significant here is Alexandrowicz's espousal of what he would later call the constitutive theory of state recognition, as opposed to what he saw as the earlier declaratory procedure, which acknowledged the identity between de facto and de jure statehood. Alexandrowicz argued that because there had never been a legal vacuum in the territory occupied by the state of Israel, Israel could not claim rights through occupation. This meant that while Israel's effective control over the territory assigned to it by the UN General Assembly in Resolution 181 in November 1947 did indeed establish its sovereignty there was doubt about its sovereignty over the land the UN had designated for the independent Arab state at the time. It also meant that while Israel was right to deny that it was a successor to the mandatory powers, rights, and duties in the former Palestine, since Britain as mandatory power had never held sovereignty, Israel had inherited other rights and duties under customary international law, including duties under private law to indemnify holders of certain concessions, for instance. Alexandrowicz saw it as being in the interest of the new state of Israel that, quotes, its present rights and duties should, as far as possible, be linked with the past. While his commitment to tracing continuities of sovereignty remained a central theme throughout his career, his use of history, his developing theory of recognition, and his belief in the obligation of new states to accept the duties prescribed by conventional international law all changed after his translation to the University of Madras in 1952. From that post-colonial perspective, Alexandrowicz's historicism became more radical and more thoroughgoing over time. Throughout the rest of his career, the bulk of it spent in India, later in Australia, and finally in London, Alexandrowicz would use historical argument to establish the legal equality of states that had been denied both under colonialism and under the post-imperial legal order. He saw the universality of the law of nations repudiated by the European-dominated legal order as a peremptory norm, jus cogens, of fundamental moral status, akin, for example, to the prohibitions on genocide and crimes against humanity. To support that strong claim for equality, Alexandrowicz set out to provide historical evidence that decolonizing societies, particularly the new Asian democracies, as he called them, were not in fact new to international society, but were in fact being restored after a colonial period that was not a starting point, but an interlude only, and, as he called it, a period of negligible duration. So from the early 1950s to the mid-1970s, Alexandrowicz elaborated and refined a picture of world history since the 15th century, in which, starting in the late 18th century, but becoming definitive in the period after 1815, a universal naturalist law of nations had given way to a distinctly un-universal positivism, as he put it, in international law. And again, he distinguishes very consistently in his writings between the law of nations, roughly pre-1815, and international law, roughly after 1815, though his chronological boundary is slightly blurry. Certainly the division, both of vocabulary and of the features of these two regimes of the law of nations versus international law are very clear and consistent through much of his mature writing. The major axes of difference between the two frameworks in Alexandrowicz's account were the scope of the family of nations, universal versus European, the approach to civilizational, religious, and indeed racial difference, non-discriminatory and multi-ideological versus what he thought of as arrogant and intolerant, and also the theory of the recognition of states, each presupposed a declaratory theory versus the constitutive theory. Here is perhaps the most succinct account, the succinct statement of what Alexandrowicz believed was lost in the translation from naturalism to positivism and from the law of nations to international law. And here I quote from his article, New and Original States, the issue of reversion to sovereignty from 1969. The universality of the family of nations, he wrote, the multi-ideological character of the law of nations, its attitude towards ideological struggles, such as the Christian-Islamic or the Catholic-Protestant conflicts, its non-discriminatory approach to civilization, religion, or race, declaratorism in respect of recognition, as well as the doctrine of bellum justum, were all functional qualities peculiar to the natural law system within the classic law of nations. What he called the elimination of naturalism and the triumph of positivism contributed to a system of international law, he wrote, which accepted colonial expansion and the institution of war as a mode of settlement of international conflicts. And again, one can only imagine the horror and despair, perhaps, with which he would be viewing the events of this week. That described the world in which Alexandrowicz had grown up, that is before and during the First World War, as well as the one where he found himself in the 1960s, into which new states were claiming entry on their own terms. Now, Alexandrowicz's claim that non-European states before the colonial interlude, as he called it, had been active makers of international law, defied the then mainstream European view that the new states were gaining, or even perhaps earning, admittance to an existing system to which they'd always been outsiders and whose terms they were in no position to question or to alter. This, in turn, led to the charge that Alexandrowicz's desire to justify universalism and sovereign equality in the present had caused him to overstate reciprocity and mutual recognition in the past. As the British theorist of international relations, Martin White, wrote in 1971, quotes, in order to correct an interpretation of the history of the state system that was exaggerated as well as being today politically unfashionable, Alexandrowicz exaggerates upon the other side. In arguing this way that colonialism was a relatively brief interlude without legal validity, Alexandrowicz arguably drew an untenably sharp distinction between the legal and the political, one that stood in tension with his general indictment of 19th century positivist international law as fully complicit with the European domination of Asia and of Africa. Alexandrowicz saw the profusion of treaties between European states and others, especially Asian commercial states, as evidence of the force of his universalist conception. He then identified a radical shift at the end of the 18th century, a global shift indeed, in which ideological transformations in Europe preceded changes in state practice, and European writers declared the obsolescence of universalism, even as European state agents continued to recognize Asian states as treaty partners. He maintained that, and here I quote him, limitations imposed on the Asian states' legal capacity by ideological change without their participation in such change could not produce such far-reaching results as their reduction to a sort of extraneity, a status which implied a serious restriction of their position in international law. That is, to translate very slightly from his prose, their exclusion from the contemporary family of nations by the bulk of 19th century legal treatises was, Alexandrowicz believed, illegitimate in legal as well as in moral terms, because the Europeans did not possessed the legal capacity unilaterally to expel states whose legal status they had once recognized in theory and in practice, and indeed, as he argued, continued to recognize in theory and in practice during what he called the European-African confrontation of the 19th century, where he found a profusion of similar treaty arrangements and therefore recognitions of sovereigns and of sovereignty in Africa, parallel to those that he had excavated in his researches on South and Southeast Asia. Alexandrowicz's key conceptual, historical, and normative arguments all turned on that distinction between a pre-19th century law of nations based on natural law and therefore, as he argued, universal, and the positivist and exclusively European hierarchical conception of international law that originated around the turn of the 19th century. And it's notable in this regard that he persistently distinguished the law of nations from international law on grounds which were not merely descriptive or chronological, but were fully normative. That 19th century view of international law was the primary target of his criticism, both historical and normative criticism, that is. Although Alexandrowicz was never quite precise about when the ideological cataclysm as he saw it had first begun, whether in the late 18th century or the early 19th century, his often repeated narrative was notable for failing, for instance, ever to invoke 1648, Westphalia, as the starting point for an alleged Westphalian international order based on mutually recognizing statehood. This aversion to the myth of 1648, as it's been called, was surely strategic rather than accidental. The irredeemably Eurocentric Westphalian story was irrelevant to Alexandrowicz's much more radical counter-narrative of interpolity relations in global history as the encounter between regimes of sovereignty, particularly Asian and European sovereignties, rather than as the export or the diffusion of any European model. For Alexandrowicz then, 1815, not 1848, was the pivot around which world history turned. For it was, he believed, from the Congress of Vienna and its aftermath that he dated the emergence of the arrogantly positivist vision of legal order Europe imposed upon the rest of the world over the course of the 19th century. Not coincidentally, 1815 also marked the moment when the last artificial vestige of Polish autonomy, that is the Kingdom of Poland, was created by the Congress of Vienna and then gradually subsumed into the Russian Empire and later into the Austro-Hungarian Empire. Alexandrowicz was well aware of the homology between the two processes. For example, he frequently compared the Maratha Confederation with the Kingdom of Poland and the collapse of the Mughal Empire with the decline of the Holy Roman Empire, as the disappearance of the two most powerful empires of the world had a decisive impact on the law of nations, as he put it. The collapse of the Mughal Empire, he believed, in rendering China vulnerable to European force, ultimately led to the collapse of the Asian interstate legal order that, he wrote, had been part and parcel of a worldwide international structure. In Europe, again, he wrote, the declining entity was replaced by a group of independent powers, the Concert of Europe, that declared themselves bound by the public law of Europe, thus establishing a new and fairly stable interpolity legal order and simultaneously declaring that law then to have global validity. The sovereignty of both India and Poland were a casualty, he believed, of this aggressively self-centered jus publicum Europaeum in the 19th century. Alexandrowicz's Polish background also explains why he sometimes antedated the beginnings of European positivism to the late 18th century, that is, a few decades before 1815. This was not because of events in Asia in relation to the Maratha Empire or the Mughal Empire, but because this was the moment of the Polish partitions in Europe. The moment, that is, when or set of moments when a once proud state was dismembered as evidence of what Alexandrowicz termed a European egocentric attitude that began with policing the boundaries of Europe and found its most violent expression in South Asia and later in Africa. Yet, he found the period also to be pivotal because it was then that the evolution of a theory of recognition, which constituted an important aspect of the emergence of international law as he saw it occurred in the crucible of the struggles between the ideologies of legitimism and popular sovereignty around and following the French Revolution. Alexandrowicz's genius for perceiving analogy across world history and for observing continuities did not obscure the differences, of course, between different phases in the life of the family of nations and of different legal orders. He was fully aware how the grip of the past might paralyze the present. History, he believed, could confine as well as liberate. He remained deeply interested in procedural questions of the formation of international law and the ways in which it would have to be radically reconsidered in light of the proliferation of states in the context of decolonization and the admission of these new states to the United Nations. For example, he noted that the weighted system of international lawmaking by which the major powers had a decisive voice, however acceptable in the homogeneous 19th century context in which powerful and weak states had similar social and economic structures, again, this is his argument, was no longer appropriate given the diversity of participating states in his own time, particularly in their economic organization, where some were free market, others communist, and the compromise solution settled on by what he argued was the compromise solution between those poles settled on by most developing nations at the time. He celebrated the new states' use of the UN General Assembly procedures to challenge the body of 19th century customary law, Eurocentric customary law, such as special protections for foreign investors, for instance, that the European powers had been using in the wake of decolonization to maintain their economic and political dominance and to limit the economic autonomy in particular of those new states. Alexandrowicz's very last publications in the 1970s, he dies in 1975, addressed pressing international concerns in those years. The expansion of the family of nations, the appearance, or rather the reappearance of Afro-Asian states, the attitude of these new states to existing international law, the need to welcome the new states into international society, unencumbered by what he saw as the prejudices of positivism and the revisions to international law demanded by the state explosion of the period. From 51 states in 1945 among the founding members of the UN to 125 by 1968 and around 140 by 1974, that is just before he passed away. In two brief articles published in the British journal Millennium in 1974 and 1975, just before his death, Alexandrowicz voiced emphatic support for the political legal strategy of using the new state's numerical majority in the UN General Assembly to revise international law. By declaring the early 1970s, quotes, a turning point in the history of international law, Alexandrowicz perhaps over-optimistically looked forward to the prospect of the new states using their overwhelming majority as a legal counterweight against the economic and political strength of the older powers in the context of the then emergent, but ultimately, as we know, short-lived, new international economic order of the time. In these articles where he dealt with these developments, Alexandrowicz was perhaps more explicit about the politics of international law than he had ever been in his career. He more openly acknowledged the fault lines of international politics between capitalism and communism, and he looked to the Latin American countries, and a region he very rarely discussed in his writings. He looked to those countries as having led the way in responding to European economic domination and legal maneuvering, especially at the UN. These terse final pieces suggest subtle but significant new directions that Alexandrowicz's thought might have taken had he lived longer. The principal commitment to intertemporal and transnational equity, visible in these late essays, as indeed throughout his wide-ranging body of work, makes Alexandrowicz the forgotten founder of the current critical movement to historicize international law. Across his long and distinguished career, Alexandrowicz was engaged in a project of recovery. His aim was to loosen the conceptual and ideological grip of what he called positivism, but which could more broadly be called the 19th century understanding of international law. He deplored what he called its fallacy of projecting the present onto the past, particularly its error of assuming that 19th century Europe's economic and military supremacy and consequent posture of cultural and legal superiority had characterized earlier relations with Asian states, for example, in the 17th and 18th centuries. He saw his own expansive vision for a more just, a more inclusive, and a more egalitarian international order as being presaged by the naturalist and universalist conception of the law of nations he believed had distinguished the modern period through the end of the 18th century. This classical law of nations, as he saw it, was in essence not a mono-ideological system. These are his words. Instead, it promoted universal intercourse in response to a social reality extending to the whole world, a process that he believed accelerated in the 19th and 20th centuries with the proliferation of new forms of interconnection and communication in posts, telecommunications, and aviation. And indeed, one of his last interests was precisely in these transformations in the international legal order wrought by changes in communications. For example, he argued the advent of satellite technology in outer space even allowed an extraterrestrial escape from the constraints of what he called merely geocentric law. Alexandrowicz's desire to establish equality in the present may have colored his assumptions about equality in the past, and therefore he may have been guilty of that projection of the present back onto the past, though he firmly believed that what he was arguing in the present was precisely a recovery of past norms and attitudes. His egalitarian project was progressive and, we might say, redressive, engaged in redress, premised on the creation, or in fact the recreation, of horizontal transnational solidarities to combat what he saw as the more damaging vertical divisions that had fractured international society in the wake of the advent of international law, and therefore across the 19th and much of the 20th centuries. Yet it has to be admitted that his vision was also somewhat utopian, based on the belief that international lawyers in particular could refine and redefine the norms that would restrain power politicians and force them to choose the path of peace. Again, the terrible irony of these ideas at this particular moment would be only too evident, I fear. His antipathy to power politics, his preference for international society and the relations between states, and his skepticism that colonialism was a useful category of historical analysis may have prevented him from seeing some of the workings of power tout court in international politics. Alexandrowicz's concern was more to expose what he called the fallacy of Eurocentric positivism as a legal doctrine, and thus indeed to reveal its failure as law, than to explore how it operated as ideology. He argued that the positivists' move to condemn the extra-European world to a legal vacuum could hardly be considered realistic. It represented a capitulation to what he called doctrinal trends rather than a sound legal argument, and the alternative account he proposed was both, he believed, legally superior as well as being historically objective. He tended, in short, to suggest that his own work could be historical and juridical without being political. Nonetheless, his consistent use of history as a critical solvent of prejudice, his commitment to a cosmopolitan law of nations, and his determination to provincialize Europe long before that move became reflexive or indeed had a name, still have the capacity to unsettle and to inspire, even in the dark conditions that we're experiencing now. For, as Alexandrowicz wisely stated towards the end of his life, we may be able to learn from the past what the present is unable to teach us. Thank you very much indeed for your attention.
Thanks a lot for the lecture. Now I open the floor for the questions. Participants can unmute and ask questions directly to sir. The floor is open.
Hi, can you hear me?
I can hear you very well indeed, yes.
Yes, my question might not be that, not very much related, but somehow I try to formulate that. So what were the impacts that of international law, during the era of C.H. Alexandrowicz, and in the current time, especially in Asia, in India. So what could be the impact and the anything that, in today's world and in the past during the Alexander.
The impact in what sense? Can you be a little more precise?
Of international law and of the making of national law and the exercise sovereignties, and I'm speaking in terms broadly, so I'm not sure if you could get my point. Right, thank you.
Yes, I mean that is an exceedingly broad question, and one that again we might say only demands a rather chastened and non-utopian answer at this moment. It's impossible not to speculate what Alexandrovitz himself might have felt about the moment that we're living through, not only because of his attachment to his home country, his home city, but also because of his quite principled and consistent objection against what he saw as power politics and what he believed could be the restraining force of an international law properly understood in terms of the earlier law of nations to restrain power politicians. He had, of course, lived through the First World War. His father was a general in the Austro-Hungarian army involved with some of those bloody sieges of that period. He'd lived through the Second World War and indeed had been displaced from Poland by the Nazi-backed regime in that country, and had gone into exile in London as part of the Polish government in exile. So he had very deep personal experience of the ways in which international law, although respected by many parties, could not itself restrain abuses or attacks upon it, such as those that took place in his own lifetime and that we're seeing today. So I think if we're thinking in the very broad terms that you put it about what the impact or the force of international law can be, on the one hand, it is very much a binding force among most members of the at least the Euro-Atlantic international order at the moment. Russia's actions have brought NATO and the European Union powers together much more closely than they had seemed to be in the past couple of years, for instance. But also it's driving wedges between other parts of the international order. China sitting on the sidelines for the moment, presumably covertly supporting Russia. What the implications of this will be for an international legal order, as well as for the international order of power, very much remain to be seen. So the force of your question is very apparent, but quite where we are heading from now and quite what help Alexandrowitz and others from his period can give us, I think remains unclear. But the hopefulness that he retained is something I trust that we can begin to recover, but also he was clear-eyed precisely about the ways in which a power political order, an order of power politics, had distorted and warped international law for a good part of its history in the 19th and early 20th centuries, and therefore that international law itself, or the law of nations, was not simply a normative defense against its abuse, but rather could be abused in turn by power politicians. So I think that's a realistic and chastened view that we might carry over from Alexandrovitz, but what the future holds, which of us can tell right now. But thank you for the question. It's a very important one.
Thank you very much for your instructive presentation once again. Have a good day.
Yes, Ibrahim, would you like to ask another question?
Yes, thank you.
Hello.
We have ma'am. Yeah, over to you, ma'am.
Thank you. Thank you. Greetings from Romania. I am a PhD student in international law. I would have liked to ask the question of how you distinguish international law from politics, because it's deeply political, and from my point of view they're totally undistinguishable. We have an international system which is not hierarchical, sorry. So there's no order, it's anarchic. We are dealing with equal parties, And as we've seen in the International Court of Justice rulings, in many cases, it's deeply political. For example, speaking of sovereignty and such issues, in the advisory opinion on the Declaration of the Independence of Kosovo. So how do you drive a wedge between these two concepts, international law and international politics, even local politics, actually?
Yes, no, that's an excellent question, but I completely agree with you. I don't think you can drive such a wedge, and certainly when Jennifer Pitts and I wrote our introduction for Alexandrowitz, we argued, and I was communicating that argument here, that one of the weaknesses of Alexandrowicz's own otherwise very sophisticated, extremely wide-ranging legal theory was precisely his belief that one could separate international law from politics. Again, an aspect of what we might think of as his utopianism, that somehow international law reconsidered in his non-hierarchical universalist conception of the law of nations could maintain an apolitical posture and through its simple normative force shrink or even abolish the realm of politics which he felt had infected international law as a realm distinct from the political. That is not sustainable. Certainly the critical histories of international law from Anthony Anghie and Marty Koskaniemi onwards, with which I'm certain you're very, very familiar indeed, have schooled us very clearly in terms both of the practice of international lawyers, the complicity of the entire profession of international law, as well as particular examples like the one you gave, that international law is political from top to bottom and always has been. That any illusion that one can separate the one from the other is just that, an illusion. And to that extent, there is certainly a limit of, as it were, the portability or the utility of Alexandrowicz's vision into the present. He was, although realistic about the wide scope of politics in international affairs and of power politics in particular, he was an idealist to the extent that he believed that it was possible through the use of history, through legal argument, and indeed through training, for example, a generation of international constitutional lawyers in India. It would be possible through all of those things to begin to roll back the frontiers of power politics, to recover the world of the law of nations, a more egalitarian and inclusive world of the law of nations, which had somehow been obscured by power politics, but not infected with it. So from any more realistic contemporary point of view, that does seem far too utopian, but at least considering that shows us exactly the force of the charge, the analysis that you rightly make, that international law and politics are not distinct realms. They're intimately bound up with each other and have been for at least 2 centuries, but accelerating in the post-war period. So yes, thank you for sharpening that. It's a very, very strong point.
Yes, Ibrahim, would you like to ask the question?
Yes, thank you. Hi, Professor Armitage. Thank you very much for that very wonderful introduction to Alexandrowicz's thought. I'm wondering if you could speak a bit to how Alexandrowicz might view the development of war in global history, and especially in relation to his distinction of the pre-1815 naturalist era versus the 19th century positivist era. I think you said that he saw the positivist era as one in which war was permitted and part of the sovereignty of states, and that would naturally be something that would horrify him. And I'm wondering if you could speak a bit to like how he viewed the relationship between sovereignty and war before, like in the naturalist era. And then relatedly, I'm wondering how he viewed or how he would view the post-war developments in international law. Like, was that some kind of return to the naturalist era for him, or how would we conceive of the post-1945 developments in the longer arc of world history? Thank you.
Yes, thank you very much. Yes, I mean, I'll take the second question first, because I think there may be a bit more concretely to say about that. Certainly, of course, his whole career as a legal academic and his publications and his observations upon the world, as it were, take place in the immediate post-World War II situation. That's where he does his historical research. That's where he writes his constitutional law. That's where he is active as an educator. So he's, as it were, participating in the formation, or for what he saw partly the reformation of an international order in that period. And I think he can be seen as using his voice, particularly from his position in post-independence India, to reshape that international legal order, not least by, again, educating a new cadre of international lawyers representing what then was already the world's largest democracy and a major diplomatic player, educating them in the new, quotes, naturalistic norms as a means of intervening in the reshaping, the reordering of a plastic international order in the period after 1945. And I think he very much saw that as his mission, though he never expresses it as explicitly as that, but it seems pretty clear that was part of the aim of his writing and his educational work, which meshed together very much along those lines, and that he hoped that through recovering an actually existing vision, a historically actually existing vision from the past, he could use that as an inspiration in the present. I mean, it is notable, and we, Jennifer and I do point this out in our introduction, that there are many aspects of the post-war international order that he doesn't tackle, doesn't even mention. Bandung never appears in his works, oddly, since he was so interested in Afro-Asian links. He almost never talks about Latin America, except at the very end of his career, as I mentioned. He only intermittently at times talks about the Cold War as a split between two economic systems. So the whole areas of the post-war international order that he does not analyze, does not engage with, maintains his focus purely on those, again, things he may have thought of as non-political aspects of the law of nations. So his work is at an angle to some of the most creative and influential efforts to intervene using tools of law into the formation of the post-war international order. But in retrospect, we can see how we can fit that into those patterns of legal ordering, collisions between different patterns of legal ordering, indeed, in that period. So going back to your first question as well, he doesn't write at, let's say, sufficient length to be able to talk in depth or detail about, for example, his theory of war. He does in some of his schematic accounts of the differences between the naturalist order and the positivist order, point to exactly the shift that you mentioned, that I'd mentioned earlier as well, to the idea of justum bellum being characteristic of the post-1815 order, that is, justifications for warfare becoming routinized and normalized, again, as aspects of power politics, and indeed as expressions of a particularly Eurocentric conception of hard-edged, even predatory sovereignty, while similar rights were not accorded to the formally recognized sovereign powers, for instance, of South Asia. So he sees that move towards the self-interested justification of war under the positivist regime as being precisely characteristic, we might even say literally the bleeding edge or the cutting edge of this 19th century Eurocentric conception of sovereignty projected out to the outside world through the channels of empire and taken away from as a right of response, as it were, of self-defense, taken away from other sovereigns that had previously been been recognized. So that is one of the diagnostic points, that the emergence of that idea of just war on behalf of European sovereigns in particular, that is one of the diagnostic points he uses to point up his analysis of that positivist order, but he doesn't have anywhere in his very large body of writings anything explicit at length or in detail, whether historical or normative, about just war, for instance. It's hints that one has to put together from across aspects of his writings. But it's a great question. Thank you.
Thank you. So there's another question posted in the chat box. I'll read it for you. There is no doubt that pre-modern Indian states had treaty-making powers. Yes, the practice of treaty-making between states is certainly part of what we can call international law, but it is quite minimalist view of international law, that international law is only about treaty-making. Did Alexandrowicz ever argue anything more than treaty-making practice in pre-modern Indian international law? Anything like the law of diplomatic privileges, jus in bello, law of maritime safety, and so forth?
I mean, the very immediate answer to that excellent question is yes, indeed he did. He sees treaty making as being perhaps the most salient expression of sovereignty, and the one that in practical terms he could recover most immediately from the archives, particularly the South Asian archives to which he had access when he was in India in the 1950s and 60s. But then looking at European treatises from the 18th century, as well as diplomatic practice, the recognition of precisely maritime passage and the freedom of the seas, for instance. He does elaborate a wider conception of sovereignty with many facets to it, of which treaty making was only the most prominent. In this, he's followed and in some senses amplified by contemporary colleagues. I'm thinking in particular of R.P. Anand, writing in India at the same time, one of the first third world historians of international law, who wrote even more than Alexandrovitz did, for instance, about the freedom of maritime passage in pre-colonial South Asia, and Anand argued controversially, probably not ultimately persuasively, that someone like Hugo Grotius gained his ideas about the freedom of the seas from these South Asian practices. That's not a widely accepted view, but Anand was building upon some of Alexandrovitz's work and pushing it further in that way. So yes, I mean, again, very simply, the answer to this excellent question is yes. Alexandrovitz concentrates upon treaty making both in South and Southeast Asia and then later in Africa, but sees treaty making as part of a suite of sovereign actions, sovereign activities, which include most of the ones that you mentioned here in your question. So thank you for clarifying that. Very important.
Would you like to take one more question?
Absolutely. Yes, please.
Okay, so we'll have one more question.
Yeah.
Yes, Omi, you can proceed here.
Okay. Hello. Thank you very much, Professor. I would like to ask one question, which is rather a tiny question, to be honest. I think you said the Alexandrovitz developed some ideas that new forms of telecommunication may change the nature of international law. Mm-hmm. Is it written in? Yeah, I got the book. I just wonder which article is actually mentioned that aspect of things, because you said towards the end of his career.
Mm-hmm. Yes, this is in the 1970s when he writes a book about a whole book. Yes, if I just zip back through, let me find the exact title of that. So it's, yes, 1971, The Law of Global Communications. That's his entire study of that, an independent study of that. There are very small hints in some of his later articles, odd half sentence or so, that show the continuity of those interests. But again, one of the things that's remarkable about him is that he writes such rich and profound and detailed works in so many different areas of international law at the same time. So as he's pursuing this extraordinary and foundational precocious career as a historian of the law of nations, He's also writing entirely separately about the organs of the United Nations. He's writing entirely separate, of course, about Indian constitutional law. And then he writes this book on telecommunications in the 1970s, which I do recommend to you. It's what many scholars are now examining, precisely the way in which international law in this period goes into outer space with, for example, the Outer Space Treaty in this period, and his work on telecommunications leads him to this extraordinary vision of escaping the surly bonds of Earth, as it was famously said, to think beyond, and this is his word, geocentric law. I can't recall, I may be incorrect, but I can't recall him using the word Eurocentric, but he does use the term geocentric.
Geocentric, wow.
A law which is centered upon the Earth to one which goes beyond the Earth to the atmosphere and indeed beyond. It's really fascinating.
Thank you very much.
Yeah, so very nice to see you again. Thank you for coming.
Yes, I appreciate it. Thank you.
So we'll take a last question for the day. It has been posted in the chat box by Adithya Roy. Thanks for the lecture, Professor. My question is, what is meant by Mundal system and spheres of influence in the writing of Alexandrowicz?
That is a good question to which I do not have an immediate answer. I cannot recall, I may be wrong, but I cannot recall his discussions of the mandala system. Again, I may be wrong about this. He has a couple of very interesting articles about Kautilya and the Arthashastra, where he may elaborate on this more broadly, but I'm not calling anything immediately to mind where he talks about that. I may be wrong. I will check further on that. Very, very interesting question, and I regret I don't have an answer for you.
Thanks a lot, sir, for answering these questions. I would like to invite Professor Lakshmi Jambholkar, Honorary Professor Emeritus at National Law University, Jodhpur, and Honorary Professor at Gujarat National Law University, Gandhinagar. Ma'am is a very senior faculty, and I fondly remember reading your articles on conflicts of laws. It's a pleasure having you here. Now over to you, ma'am.
Thank you very much. Good evening. First and foremost, I'm extremely thankful to have given me a chance to address the concluding session of Professor Alexandrovitz's memorial lecture. I am doubly thankful as Professor David Armitage is speaking on very important and timely concerns on international law regarding sovereignty and statehood in the work of C.H. Alexandrowicz. Professor Armitage has published a work on Alexandrowicz titled The Modern Grotius. When you talk of Grotius, you know, you really become highly sentimental, because that's where we started when we began our law courses in international. An introduction to the life and thought of Professor Alexandrowicz. It is one of the outstanding works of Professor Armitage, who has a wide range of scholarly work, from history to international law. The article entirely covers his legal thought and contribution to international legal problems. Some of the aspects have been discussed in earlier two lectures by eminent scholars, namely Dr. Khare and Professor Sonaraja, brilliantly. Both the themes covered India's historical past and its contribution to international law up to independence. Professor Sonaraja, while dealing with the resistance and change in international law, criticized Alexandrowicz for not taking into consideration the international developments happening during his time, like Bandung Conference. As is known, Professor Alexandrowicz was heavily dependent on the role of history of international law. To quote, and I believe in so, we may be able to learn from the past what the present is unable to teach us. But my understanding of conflict of laws and private international law, perhaps this may not work, depending too much on history, because it's built in every day, almost every day. That's the reason. I'm very much impressed about what is referred to as Madras School of Law. It has been rightly observed. Alexandrowicz trained leading scholars in the field of international law during his stay in India. Here I would refer to the contribution of Professor T.S. Ramarao, who took the reins of the department after Alexandrowicz. He has contributed substantially in his writings in the Indian Yearbook of International Affairs, very authoritative. But interestingly, he moved on to private international also. Similarly, Professor M.K. Nawaz, also a student of Professor Alexandrowicz, contributed vigorously on issues of international law, and he worked with Professor Oscar Schechter in UNITAR. After he came back to India, Nawaz contributed to the Indian Journal of International Law as editor. During this tenure, the Indian Society of International Law became a vibrant institution under his leadership for a decade. Other students like Dr. P.C. Rao, Narayan Rao have done extensive work on legal issues concerning India. For example, Dr. P.C. Rao was elected as the chairman of the Law of the Sea Tribunal at Hamburg. Similarly, Dr. Khare, Narayan Rao, a gold medalist in the department, pursued his public life as a constitutional lawyer and became a member of parliament in India twice. Likewise, it's a great contribution for Professor Alexandrowicz to the Indian legal education, and eminent academicians and jurists will remember him for time to come. As a student of Professor T.S. Ramarao, I followed his footsteps as a teacher in University of Delhi for 30 years teaching in international law and private international law. I was impressed by Professor T.S. Ramarao's contribution to the 1955 edition of Indian Yearbook of International Affairs, wherein his article ran up to 100 pages on private international law in India. It's a classical work. This article was totally analytical, explaining the Indian position of private international law. I was also associated with Indian Society of International Law for the same period, wherein Professor Nawaz, as a director, guided me in my writings on public and private international law. There are other students of Alexandrowicz, like Dr. Krishna Shetty, Professor Arabi, Professor Govindraj, to name a few, as teachers of international law and conflict of laws. So the immense contribution of Professor Alexandrowicz is unparalleled in the Indian legal history, and now we see the proliferation of law through universities and colleges all over India. But we must not forget that Madras School of Law, the Department of International Constitution, established by Professor Alexandrowicz, remains an outstanding feature. Mention has to be made the manner and style Professor Alexandrowicz had followed in carrying out his commitment in the department which he has established in Madras University. He did not follow the routine systems of course content, syllabi, reading material, etc. He divided the course of international and constitutional law into 5 papers, namely Public International Law, Indian Constitution, Comparative Constitution, International Institutions, and Private International. The canvas was left open for the students for a free study of these papers using the library extensively. Indeed, the classroom discussions over a period of 10 years, culminated into the bringing out a book titled The World Economic Agency, published in 1962. I was told in one of my conversations with the students that in the formation of this, coming out of this book, almost every classroom lecture was so much interesting that that ultimately it was necessary that they had to bring it out in the form of a book, so rich in its content. And we had a lecture on Professor Alexandrovitz's work on this book. The then Chief Justice of Madras High Court, Anil, while giving the inaugural lecture to the fresh LLM students, I joined the department the year in which Professor Alexandrowicz left India. That was, it could not have been possible otherwise. I was told that every time the book was finalized, Professor Alexandrowicz torn it into pieces. And he repeated this 12 times until it became the perfect book. Give an example that don't refer to your previous editions or previous workings. Think afresh. Well, the World Economic Agency, published in 1962, we stood aloof from this other contributions during that decade. His interest in conflict of laws can be traced to his earlier writings and his doctoral thesis on Polish marital law and history. Because of the developments in Poland, marriage issues resulted in confusions on matters of marital consent, dissolution, divorce, and remarriage. Have given a fertile ground to work on conflict of laws, and he termed its problems as comparative law. Interestingly, in 1953, he constituted an Indian Committee of Comparative Law. I mean, this has already been referred to in earlier today itself. There's no point in repeating it. These developments might have influenced his inclusion in private international law in Madras University scheme, and the subject has assumed importance and is being taught in almost all the universities all over the country. It was a misfortune that we missed out his thoughts on this subject, which would have been made a lot of difference. Coming to this lecture on sovereignty, statehood. In the historical context and modern terms, Professor Alexandrovitz's views on the subject are, to my mind, distinctly separate and original as to the emergence of new states and their contribution to the international law during his time. Dr. Armitage, you have very rightly pointed out in your concluding remarks that his posthumously published essay, Are we to carry on with the outdated axioms of historians of international law, still basing the universal international law valid for all contents on nothing but Western history? This question still persists if one sees the developments of the world today. For example, the present crisis between Ukraine and Russia. There's lots issues on sovereignty and territorial integrity and the state's existence to its recognized boundaries. Here, the UN Charter was invoked for restoration of sovereign rights and territorial integrity of Ukraine. So these new questions on the issues related to sovereignty and state in the present context need to be looked into from the international point of view. In fact, my heartfelt thanks to Professor Armitage and for his scholarly contribution. I profusely thank the Vice Chancellor and his team for having this memorial lecture on the modern groceries. And I also urge the universities to honor him by establishing chairs in his name in further studies in international law. I wish the University of Madras should take also an initiative on this matter. In fact, I wanted to share one more aspect. My Professor T.S. Ramarao. So, best contribution was that private international in India, which ran for more than 100 pages, published in the 1955 Indian Yearbook of International Affairs. And he encouraged me also to write a long article in private international law in the most tough subject, private international law concerning negotiable instruments in India. Well, this was also published in the 1965 Indian Yearbook of International Affairs. As I was asked to give only the concluding remarks, I wish I had known that I should have given a lecture on conflict of private international law. Well, right now, I was working on the India's accession to the 1980 Hague Convention on the International Child Abduction Convention, 1980, which India is not going to, and it has refused. And instead, I refer you anyway to everyone to study a committee report that has come out in this context by Rajesh Bindal, Justice Rajesh Bindal Committee, which is one of the best well-written report without taking any sides or giving any advice to the government as to its accession or not. However, they and analyzed all issues of the child abduction, international child abduction, and also considered the pros and cons of all the parties who have got stakes in this. And it was not necessary because, and having suggested mediation as a procedure to sort out the problems. His advice will be that India has got the best alternatives for childcare in the extended families and the joint family systems. So that itself conveys the message that Hague Convention on the Child Abduction need not be dependent. Thank you.
Thank you.
Thanks a lot, ma'am, for delivering the concluding address. Now I request Adithya Variath, sir, coordinator of Center for Research in Air and Space Law, to deliver the vote of thanks. Over to you, sir.
Hello, I'm audible. Yes. First of all, I thank Professor David for sparing our valuable time. And it's an honor to have Professor Lakshmi Jambholkar with us. She's someone whom we admire a lot in this field. To deliver the concluding address, I must also tell you, Professor David, that Professor Alexandrowicz is someone who was much ahead of our times, and his works were largely forgotten. And as students of international law, we owe gratitude to you and Professor Jennifer Pitts for bringing out his work and ensuring that his name is a part of international law's discourse today. I also take this opportunity to also mention that this idea of hosting this memorial lecture actually came by reading your work. So it's very important for us that you are a part of this lecture series. As Professor Prabhakar Singh always says, that the next frontier of third world approaches to international law lies in deconstruction of law, not just deconstruction of studies, but also and theories, but also deconstructing and reading critically about theorists. So Professor Alexandrowicz remains a central figure to us in this aspect. We are very thankful to Professor David Armitage for accepting our invitation. It was a dream to have you as a part of this series. Thank you for sharing your valuable time. Professor Lakshmi Jambholkar, ma'am, it's an honor to actually meet you, even though it's virtually. We hope we can associate with you in our future programs. I also take this moment to thank our Vice Chancellor, Professor Dr. Dilip Ukey, sir, not only for delivering the opening address, but also giving us this platform so that we can ensure that Professor Alexandrowitz, his name and his work resonates with the future generation. It's a humble effort from our side towards deconstructing law. We hope that we have your support and mentorship for our future programs as well. Thank you so much. And to all our participants, thank you so much for joining and for sparing your valuable time. It's a weekend, we understand, but we thank you for accepting our invitation. We hope to see you all in our future programs. And also our media partner, Bar and Bench. They have been fundamental in ensuring that this work gets publicized. So we thank all of you. We hope to see you again soon. Professor David and Professor Lakshmi, ma'am, we hope we can have you at our campus very soon. Thank you so much.
I hope so too. Thank you very much.
Thank you.
Bye. Have a wonderful weekend.
Thank you everyone for joining us. We are looking forward to have you for the upcoming events. Thank you very much.
Thank you. Thank you.
Bye. Thank you.
Thank you. Bye.